Okay, good morning, everyone. As I said, welcome to our webinar this morning. We are thrilled about this webinar just because of one, the beautiful guest speakers that we have with us. Normally, it's just Renee and I, so we're excited about that. But it is about scaling your workforce and maximizing your talent. And what is exciting about the month of October is it is National Women's Small Business Month, and since Renee and I started DPI, we committed in October to bring just relevant information to our business owners just to celebrate this month as a woman-owned business. So this is brought to you by DPI LLC, which is a business consulting firm. Renee and I are both the co-founders of it, and then Renee Scott Insurance. So we are just excited about the information that we have for you today. Just to let you know, on December 1st, just a few announcements. We will have at 8:30 a.m. another webinar, and this is all about strategic planning for 2024. I have been in deep work in the month of October thinking about 2024. And so if you don't know how to kind of start, what direction you want to take, how to start creating goals, how to move forward, we invite you to join us. You can open your camera, scan the QR code, but we will definitely be putting information out just like we did about today's webinar about that session on December 1st. And I can't believe we're already talking about December 1st. Just to let you know, if you would stay muted, we will have question and answer, and please, you can definitely come off of mute at that time, but we are recording this. Also, the disclaimer that this is for educational purposes only. Any decisions that you make, you seek your own HR consulting or legal counsel as it needs for your business. All right. We also have a DPI YouTube channel. So anytime we do a webinar like this, we do put it on our YouTube channel. Renee can definitely put the link into the chat. So if you want to subscribe, I would say watch the video first and then subscribe, because if you just go and subscribe now, you know what happens. Google will see that as spam. And yes, YouTube is owned by Google. So watch a video first and then subscribe. So today's icebreaker, normally we ask, like, do you have shoes on? Yes or no. But we wanted to ask, what is your favorite business app? You can put it in the chat. I think it's just a great space that, as we are all business owners, what is your favorite business app that you use all the time? And I think we might discover some new tools that we can use in our own business.
Roslyn, what is yours?
So mine is Google Calendar. It's my #1 tool that I use every day.
Awesome. Mine is Thrive. I use my Thrive app almost every day. So Thrive is the entity that hosts my website. And so I love my Thrive app because I can see my appointments, any type of emails that are coming in from customers. I can have all of that right at my fingertips.
Awesome. All right. QuickBooks. Lorna, I see you. Lillie, OneNote. Okay. Anyone else? Yep. Nadine, Google Calendar, Monday. And Valerie, you help keep people organized. So I was waiting to see what you were going to say. Monday.com. Erica, Marco Polo, which, if you haven't used that app, that is a very neat app.
Yeah, Marco Polo, I'm in the coaching business, and it allows me to connect with my clients on a touch point basis without me having to be in text or whatever. It's all recorded there. So Marco Polo has been phenomenal for me with clients. And Popple is because it's an easy way to do the business card.
Yeah.
It's a digital business card.
Yeah. Ring. Keisha said Ring. Okay.
Yeah, Ring Central. Yeah, for phones. I use mine a lot as well. Yep.
Okay, I was like, I don't even know what that is. All right.
Yep.
So Renee?
All right, so I am here to introduce our first speaker, Lillie Anthony. She is the founder of A&A Financial Tax Services, an exclusively virtual online accounting and financial tax firm, delivering accounting, financial auditing, and tax prep services since 2016. Lillie is a certified enrolled agent and can service clients in all 50 states. She is a retired special agent with the IRS, and she worked with the IRS for over 23 years as a criminal financial investigator and revenue agent, auditing businesses and individual tax returns. So she is a powerhouse. She also served in our military in the United States Army. She was captain in finance and accounting. She specializes in a variety of financial and tax solutions, including IRS tax audits, tax planning, tax prep, QuickBooks accounting, as well as audit reviews. She just shared with us that she has a new grandbaby. And so, Lillie, thank you so much for being here this morning. Take it away.
Thank you. Thank you. Good morning. Good morning. What we're going to talk about today is hiring employees versus independent contractors. And if your business is growing and you need additional help, you do want to hire employees. And sometimes we classify our employees as independent contractors, which IRS looks at it as a no-no. You can't classify everyone as an independent contractor. So in order to determine which work classification to use when hiring, you must have an understanding of what is required of an employee versus an independent contractor. Start with listing the duties and responsibilities of what you want that individual to do. An independent contractor, you're going to have a contract, you're going to have a specific job or a specific task they're going to be working on. An employee is going to be coming in doing the routine, everything work flow throughout the day. And the most important thing to remember is control. You as a business owner, you have the control over that individual employee or independent contractor. So let's talk about what is an employee. Employee is a person that you hire to work in your business, to perform a daily task, answer the telephone, filing, just doing routine task work, and you're controlling that individual at all times. Whereas an independent contractor, they're self-employed. A self-employed independent contractor not only just work for you, they also work for other individuals, other organizations, because they're on a contract only. They're not just exclusively yours to work with on a long-term basis. And again, the control element is the most important thing. You can control the daily workflow of an employee, but an independent contractor, they may only be available for so many hours a day, or they may only be available just to complete that task that you assign to them. So let's look at some of the pros and cons. Employee have a consistent salary, insurance. They do have fringe benefits. They're allowed to have fringe benefits, because if you set up insurance and fringe benefits for yourself as a business owner, by law, the employees are required to have available those same type of benefits. They have fixed hours. They pay you as the business owner, you pay their taxes. Some of the cons: lack of freedom, subject to changes, salary restrictions. Whereas with the independent contractor, they have flex hours. They have more earning opportunities because they can work with other business owners. Self-employed individuals pay their own taxes. No benefits unless they set up their own retirement income, retirement accounts and things like that. And they use their own resources. So how do we avoid misclassifying employees versus independent contractors? The most important thing is to know the federal and state requirements. IRS is federal, you got Department of Labor, and you have state requirements. Each one of these agencies have their own restrictions, how they classify employees versus an independent contractor. So if the only one we're going to talk about today is IRS, the 3 common law rules that requires you to classify individual as the independent as a employee. And with under the IRS 3 common rules, you have behavior, financial, and the type of relationship. With behavior, who controls the rights to that employee? Do you instruct the worker when to come in?
Mhm.
Are you supervising the employee all day? Do the employee has lunch breaks, vacations, and things like that? Financial, how much you're paying the worker. By state law, we have minimum wages, so there's restrictions for paying for employees. And then relationships, what type of benefits are you allowing the employee to have? And to avoid these risks, if you follow the 3 common law classifications, you can avoid penalties from IRS, because when IRS comes in and do an audit, that audit, once the employees are reclassified, the independent contractors are reclassified back to employees, you can end up paying failure to file penalties, failure to pay penalties, and interest, because now they've reclassified a full 12-month year of independent contractor salary to quarterly payroll tax salary. So then it increases up to a lot higher for penalties and things like that. And in summary, I'm sorry, in summary, remember to get familiar with the 3 common laws: behavior, financial, and relationships. And the key is control. If you control that daily work schedule of that individual, they're most likely are not an independent contractor. Because say, for example, you hire a receptionist, they're working 6 hours a day. The only casual, and I understand that, but yes or no, if they're really an independent contractor. And I remember one time I was doing some consulting work for a business owner, and she had a receptionist that came in every day to work her phones, and she had her listed as an independent contractor. And when I tried to explain to her that she really wasn't an independent contractor, she decided she didn't want me as her assistant anymore. So it worked. It's fine. But I try to educate my clients that if you at least agree and minimize how can I put it? Just minimize the keep the requirements up front, that these are the pros and cons. And if you stick with them, usually you won't fall into those audits and the penalties and things like that. And if you can't decide on how to classify an employee, there's an IRS form, SS8, that can be used to let the Internal Revenue Service make the classification. And usually if IRS comes in and assists you in making a classification and they give you a determination letter, the Department of Labor and the state, usually they're going to follow suit with the same requirements. So once you get a determination that this individual is a employee versus an independent contractor, usually you're okay. And also I look at, sometimes I try to review over exactly what this individual is doing. Because sometimes you can be say for example, a consultant, and you hire another licensed consultant, and they're helping you with your workflow each day. Technically, yes, that individual could be an independent contractor, but now if this individual is working with you every day, using your clients, performing the same tasks you're performing, you're directing them how you want them to perform those tasks, most likely that consultant is actually your employee. But that's one of those gray areas that if you want to fight it and say, okay, I want them to be an independent contractor, get Internal Revenue Service involved, the tax examiner, and let them help you decide yes or no, this individual can actually be a independent contractor. Because IRS focus more on employees versus the independent contractor. The payroll taxes is where the government earns their revenue from. So they're more focused on the employee misclassification versus an independent contractor. independent contractors, as long as you file the forms 1099, government knows they're going to collect the income, the taxes on the income from the forms 1099. So is there any questions that anyone have for me regarding classification or some examples of different employees versus contractor?
Lily, I have a question. What if a business utilizes, say, a virtual assistant, a 1099 virtual assistant? That individual is working with the business on a daily basis, but it is at that 1099's time frame. Like sometimes they work 8 to 2, sometimes they're working 2 to 5. What would you say about a virtual assistant? Is that a true 1099 or should it be classified as a W-2 employee? Because I know a lot of businesses are using virtual assistants now.
Okay, with the virtual assistants, that's one of those great areas I was talking about. With the virtual assistants, remember that virtual assistants in business for themselves. So they're not only working with you, they're also contracting out with other individuals. So yes, technically a virtual assistant, if they are set up for a business and they're contracting to different individuals, yes, they can be considered as a 1099 because you hired them specifically for that day, that that specific task. So yes, that because they're not on a regular basis, most virtual assistants, they're as needed. So that's one of those great areas that yes, this individual. Now, if you hired a virtual assistant and that virtual assistant is only working for you only, they're not hanging out shingles that advertising that they're in business and paying self-employment taxes, the examiner could argue like, oh no, this is your employee. This is not a virtual assistant.
Okay. Erica, I see you have your hand raised.
Yeah, I just heard what you said because that was actually my question. I have a virtual assistant that I'm helping her develop her business as well, right? And so eventually she is going to be providing services to different venues, and she currently does actually with another company. But she gives me 2 hours a day virtually where she does work for me. So is that still the 1099 or, because, and she, yeah, I wasn't sure if she is a 1099 or a W-2 and she pays, like, I'm still unclear because of my
I would
particular.
say she's still a 1099. If she's starting and getting her business up and running and she have an occupational license, see, there's another thing. Most self-employed individuals, they have some type of license. They have either occupational license, certification as an accountant or attorney or doctor or something. It depends on those licenses. If she's gonna, if she's gonna be setting up her business, have her go ahead and apply for her occupational license. So then you can articulate this individual is in business for herself too. And that's what it really boils down to when the examiner is looking at all of the facts. How can you articulate that this individual is working and how their business is structured?
So she's a 1099 as I presented it for right now, right?
Yes, she will be okay.
Thank you.
So I have a question on behalf of, as a business consultant, I know that there are a lot of businesses where, let's say like a nail salon, or I'm thinking even about Lorna, who has a massage therapist, a massage studio. For those people who are like renting booths or a nail salon, hair salon, but they're there every day, really independently, is that
you said the key, renting a boot. If
okay?
They're renting a boot, they're in business for themselves.
Got it. Okay.
If they're coming there to that salon or that hair nail shop or whatever, if they're coming there working and using your supplies and using your customers, they're really not a independent contractor.
Okay.
Jerry asked a question. What kind of record keeping would the business owner need in like a questionable situation? What would the IRS want to see?
For relating to employee versus independent contractor?
Yes.
The duties and responsibilities. List out the duties and responsibilities, what you want that individual to do, and how and what type of agreement the two of you have. And then depending on your agreement, it's going to determine how much control you have over that individual. And the key is that control. If you're controlling that individual, Most likely they're not an independent contractor because
Okay.
the independent contractor is self-driven. They have a task, they have a function to perform, and they go for it. And then they're not being supervised and monitored.
All right, awesome. Lillie, thank you so much. Really, really great information. Of course, if you need to have any type of further questions for Lillie, she is offering free consultation. So her information is there. Maybe take a picture of it. I am going to move to our next speaker, who is Camila Perry. She graduated with both her Juris Doctorate and her MBA degree from Stetson University and Stetson University College of Law with honors in 2002. She began her career as a business litigation associate with two top-rated firms. Her legal experience includes labor and employment, insurance coverage, insurance defense, commercial litigation, business tort, product liability, along with white-collar criminal defense and public utility matters. In January of 2018, however, Camila assumed the role of executive director and general counsel for the Ninth Circuit under the Honorable Aramis Ayala. I hope that I'm pronouncing that right. And in January 2021, she continued the role under the Honorable State Attorney Monique Worrell. In her role, she serves as the office's legal counsel, head administrator of office operations, including fiscal management, HR, legal compliance, public records, and information systems. She's also a member of the faculty at the FAMU College of Law as an adjunct professor, where she taught classes in law office management and contract drafting. I did want to share just a couple of her achievements because she has a long list of achievements, but what stood out is for 9 consecutive years from 2013 to 2021, Camila has been named a super lawyer by the Florida Super Lawyers Magazine for employment and labor law, an honor that is only given to no more than 5% of all attorneys in the state of Florida. She's also been named and listed as 100 most influential African Americans in Tampa Bay. Camila, we are so happy you are here. Thank you.
Thank you. Thank you very much. So I am really happy to be here, and I love sharing information as much as I can, because the more information you have as a business owner, the better off you'll be. The more information, the more tools you have to make sure that you're not making any mistakes, the least likely you are to be sued and have to litigate and spend a lot of money on things that you could have avoided from the beginning. So I just want to talk about a few common legal pitfalls that I see in my practice. And I think the first thing business owners have to know is what laws they have to comply with. And most employment laws are based on, compliance is based on how many employees that you have in the first place. So not all employers have to deal with all employment laws. It depends on how big your company is. Okay, can I ask how many roughly employees that our guests have? Are we dealing with, how small are we dealing? 5 to 10? Anybody have like 20 or more? So most of us are 20 or less.
Mm-hmm.
Okay. Okay. So I think the ones I want to go over are the ones that apply to essentially all employers. And the first one is the Fair Labor Standards Act, which is the biggest one and the one that most employers get in trouble with. And that's the one that requires employers to pay their employees minimum wage and overtime. And it's a kind of complicated law because it has a lot of rules and requirements that you really have to understand. And like, for instance, you have to pay your employees overtime in the week in which they worked. A lot of employers try to say, well, you worked 45 hours this week. You worked 45 hours this week.
Can you call mom?
So
Calling mom's cell.
So you worked 45 hours this week. So next week, I just want you to work 35. That way I don't have to pay you any overtime. You can't do that. That's a violation. A lot of employers say, what's the big deal? She only, she got paid for the hours that she worked. That's just not how it works. Things like that, you have to kind of understand. not everybody is exempt from overtime, or you can allow to be exempt from overtime. There are only specific categories of people who do not have to be paid overtime. And those are executive employees, and those are people whose primary duty is to manage the business. So think about your high-level managers, and they must have at least 2 or more employees underneath them that they have the authority to hire and fire. So you're talking about high-level management. You don't have to pay them overtime. Another group of people that don't have to be paid overtime are administrative employees. And those are people whose duty is to perform office work that's not directly related to the general business that the company does. Like if you're running a daycare and you have a receptionist and you have a HR manager, an office manager, people like that who are not providing daycare services, they're providing the administrative services for the business. You can exempt them from overtime. And then professional employees, your doctors, your lawyers, people who are degreed. If you're running a practice of lawyers, you don't have to pay them overtime. So it's a very, very defined group of people who do not have to be paid overtime. But for the most of the labor population, you have to pay them time and a half for any time they work more than 40 hours in 1 week. So some of the pitfalls that the FLSA that a lot of people could fall into is that they pay their employees a flat salary without figuring out how many hours they actually work that week. You just pay, we agree you're going to make $400 a week, and that's it. But if they work 45 hours or 35 hours, you have not paid them, you have not calculated their hourly rate to know how much you will pay them overtime. Fair to allowing them to work off the clock. That amounts to slavery, really. You cannot allow your employee to clock out and then continue to work, even if they want to work. Some employees will say, "I just want to get this work done. I don't want to come in on the weekend. I don't want to deal with this. I'll just do it." You can't do that. Volunteers. A lot of employers want to have volunteers, and for private businesses, there's really no such thing as a volunteer. You have to pay them if they're providing a benefit to your business. Now, you can have like interns who, if they are working for you for their benefit and not yours, like they get a college credit or they get something else, then you can have that in your business. You don't have to pay them. But you have to be careful with letting people volunteer to do the work that brings you profit. The other biggest pitfall is what Ms. Anthony discussed, is labeling employees as independent contractors. It doesn't matter how many agreements that you sign. Doesn't matter if you say I'm an independent contractor. Doesn't matter if you agree to it and you have this big, beautiful agreement. If what they do is integral to your business and they are working for you and they're not independent, then they're not an independent contractor, even if you both agree that you are. And I won't go into there's a test that the Fair Labor Standards Act uses called the economic reality test. It's not, it's kind of similar to what Ms. Anthony discussed with the IRS's test. So I won't go through it, but it basically boils down to how much control you have over your business. So the penalties for not complying with the Fair Labor Standards Act with the IRS, misclassification can, result in back taxes for up to 3 years. And as much as 41.5% of a contractor's wages. And I think that the IRS also can see criminal convictions if you misclassify. I'm not sure. Correct me if I'm wrong, Ms. Anthony. But definitely the Department of Labor will go back at least 3 years and they'll levy fines for misclassification and your failure to keep records about how many hours your employees have worked. You have to keep records, because if you don't keep records, the court is going to take your employee's word for it. And they're going to say, I worked tons of overtime and I never got paid. And here are my records. And if you don't have your records to say that that's not true, you will end up being liable. So record keeping is required under the statute, and it's also very important. Also, I wanted to say that you got to make sure that you're not deducting any amounts from their pay that would take them below the minimum wage. Some employers will say, here is your paycheck, but I'm taking out money for your uniform. I'm taking out money for your lunches I provide. And then all of a sudden they're making $6 an hour, which is a violation of the Fair Labor Standards Act. So you have to make sure you're not making improper deductions and that whatever they take home is above the state minimum wage and the federal. So that's the Fair Labor Standards Act, and there's so much to that act, but it would take us forever to give you all the pitfalls, but those are the main ones. The next law that applies to virtually all employers is worker compensation. It's just really important that you have workers' compensation insurance because it is really expensive not to have it if you're caught without it. If you have 4 or more employees, then you have to have workers' comp insurance unless you're in the construction business and you only need 1 employee. So that's important to know. And the main thing is that workers' compensation investigators can come to your job site anytime unannounced and say, hey, do you have insurance? What's going on here? And if you don't, then they can levy fines and they can shut your business down. So that's not good. And the fine is double what you would have paid in your workers' compensation premiums. So, or a minimum of $1,000, whichever is greater. In addition to that, they levy a fee of $5,000 for every worker who has been falsely classified as an independent contractor. So that's why all these laws are so important and they kind of work together. So it's just cheaper because the cost of not having workers' compensation is way, way, way more. It dwarfs the price of getting the insurance in the first place. And then also, if you don't have workers' compensation insurance, your employees can sue you if they get hurt. If you have workers' compensation, they can't sue you. So there's just tons of benefits to having the compensation insurance. So, it's important. Unemployment tax is also required for everyone. The biggest thing there is what you pay in unemployment taxes is based on your employee experience rating. So the more turnover you have, the higher your rate's going to be. So you want to develop policies in your business that kind of decrease layover and turnover. You want to have a good workforce that stays on for a long time, so you don't have really high taxes to pay when they are terminated. And a lot of employers say, well, I'm not going to pay for this employee to have compensation. She stole from me, or she didn't do her job. It doesn't matter. It doesn't matter. If you are terminated, basically for any reason, I mean, even theft nowadays, the unemployment, the state will probably pay them out their unemployment compensation. OSHA is another law that all employers are required to comply with, but I will say that is more heavily regulated in industries with hazardous businesses like construction sites and things like that. But every employer must keep their office and their workspace safe. And this kind of became a bigger issue during COVID because a lot of employees wanted to sue their employers for not shutting down, for making them come to work. And they cited OSHA as this is not a safe place for me to work. It didn't work because no courts could tie COVID to the workplace because you could have gotten it from anywhere. So it wasn't a thing. But OSHA is something that you should read up on and figure out how your business needs to comply with it. And USERRA is another law that requires you to give preference to veterans. If you have a veteran that works for you and they go off to serve for 5 years, when they come back, you got to give them their job back. And you can't discriminate against them for leaving to serve in the military. A lot of people don't know about that law, and a lot of veterans use that law to sue when they can't find work. There's a question in the chat. Employee record keeping. Oh, I'm sorry. I missed it.
So the first question was, are there template forms to keep track of employee work hours? That was the first question.
Forms. I'm sure there are very many samples of forms you can use. You can get payroll software. You can get, timesheet software. You can get a time clock where you actually punch in and out. That'll keep all the records for you. There are plenty of options. I can do some research and send out some suggestions.
And then the next question was employer record keeping for hours worked. Do you have to track daily totals or actual hours worked?
I'm not sure I understand the question. You have to track all hours actually worked every day. And you need to know how many will work in a work week. And you can choose your work week. If you know your employees work shorter hours on Fridays, you can have your work week from a Tuesday to the next Monday. So you can figure out when you're less likely to have to pay overtime.
Okay.
Does
And
that make sense?
then it does. It does. Is there an exemption for the USERA law
There
we
are,
discussed?
but they're very specific, and I can't remember them off the top of my head. I can't remember. There are some, and I can find that out and send it out also, if that will help. Let me make a note of that.
All right, perfect. All right, I will let you get back to your presentation.
The other laws kind of apply to larger employers with at least 15 and 20 employees, and that's Title VII and the Americans with Disabilities Act. And those are the big laws that protect people from being discriminated against because of their race, their sex, their age, national origins, skin color, all of that. And it's funny that small businesses don't have to comply with that. So if you have under 15 employees with Title VII, if you fire somebody because they're a woman, you don't really have any liability. I recommend following all the laws to the extent you can, because the spirit of the law is to protect the employees and to treat them fairly. So, I hate to tell people that you don't have to comply with this, but you don't. The Americans with Disabilities Act is a big deal because that requires employers to accommodate an employee who has a medical condition. And you must accommodate unless there's an undue hardship. And the undue hardship is an incredible barrier to overcome, because a lot of people feel like I can't afford to give my employee a bigger laptop because they have vision problems. I can't afford to build a ramp outside of my office because my employee is in a wheelchair. So I'm just not going to hire him. You can't do that. You have to. If the only reason you're not hiring that person is because they're in a wheelchair and you don't want to build a ramp, you'll be liable and you'll be sued, and it'll cost you a lot of money to overcome that discrimination. So you have to go through what's called an interactive process. You have to speak with the employee. You're not allowed to ask them what their impairment is. You can only ask them, how does their impairment impact their ability to do the job? Which means you have to know exactly what the job is, which means you have to have job descriptions. If you don't have a specific description for what the job is that you want your employee to perform, you can't figure out if they can do the job with or without an accommodation. And that's what the law requires. I feel like I'm way over 10 minutes. Am I close?
You are over your 10 minutes, but
Okay.
we're ahead of time, Camila.
Okay.
So yeah,
Okay.
we're a little bit ahead of time. So you have like another 5 minutes.
Okay. Excuse me. And then let's see. Employers with 50 or more employees, and this is huge. This is the Family and Medical Leave Act, and this is for big companies. And this requires employers to allow their employees 12 weeks of leave to take care of a child, to give birth, to take care of a person in the military who has gone off to active duty, if you're adopting a child, or to take care of yourself for a medical condition. You get 12 weeks leave, unpaid. You don't have to pay them. Most employers allow employees to use their leave, vacation or sick leave, in conjunction with your FMLA leave, so they don't have to go unpaid. But you don't have to pay them. You just have to leave their job open. And refusing FMLA rights is a violation of the FMLA. Retaliating against someone for taking FMLA is against the FMLA. If you count their absence as like a discipline against them, that's against the FMLA. It's almost like if you're on FMLA leave, your employer cannot count it at all. They can't. It's almost like it didn't happen. So if you're out 12 weeks and they say, well, you weren't here, you didn't do your job, it doesn't matter. You were out because of FMLA. So anything that happens on FMLA is kind of like off limits, and that's why it's such a scary law. And a lot of employers feel like I can never fire anybody if they take FMLA, and a lot of employees take it for granted or take advantage of it, and they say, I'm sick, I need FMLA, so they can keep their jobs. That's not exactly how it works, but it's not far from it. The other thing I wanted to talk about was some new employment laws that I think business owners need to know about. And these are brand new this year. One is about immigration. There's a big crackdown by the DeSantis administration to detect undocumented workers. And it's called Senate Bill 1718. And it now requires employers with 25 employees or more to use E-Verify. And that's a federal online database to confirm whether someone is eligible to work in the United States or not. It used to be that private companies did not have to use E-Verify. Only government agencies had to use it. Now everybody has to use it if you have 25 or more employers. And the thing about it is, if you fail to use it, you'll find $1,000 a day. But the penalty only applies if you fail to do it 3 or more times in 2 years. So it's not the first time you don't do it. You get a few times not to do it, and you get 2 years not to do it. But it's pretty steep. It's pretty, it's pretty strict. It's a lot stricter than other laws in other states for immigration purposes. The other one is the Stop Woke Act. Now that provides that the employers can sue their the employees can sue their employers for trainings, for discriminatory practices if they discuss prohibited topics under the Stop Woke Act in the workplace. And what's prohibited is any type of training that talks about concepts that make people uncomfortable. That's what the law says, literally. If you do a training that makes your employees uncomfortable, they can sue you for discrimination. It's vague. No one knows what it means. It's currently in litigation right now. So we'll have to wait and see what the 11th Circuit does with this act, because it's so, to me, insane. I can't imagine how it's ever going to be enforced. But it is a law, and it is something employers need to know about. You only need 15 employees or more to be subject to this law. And the last one is the Pregnant Workers Fairness Act. Pregnancy did not be protected under Americans with Disabilities Act, because pregnancy is not a disability, and you didn't have to accommodate pregnant people. So this is a new law that requires employers with 15 employees to provide accommodations just for pregnancy. It used to be that if you're pregnant and then you get like gestational diabetes, now you have a disability, now you have to accommodate the pregnant person. But without some sort of complication from a pregnancy, pregnant women just had to kind of suffer if they had problems or they were, needed some sort of accommodation. This act makes it a requirement that pregnancy in and of itself can require an accommodation. And the last thing I wanted to talk about, am I up? Okay.
Sorry,
Oh no, she missed it. Yeah.
Okay. I just wanted to kind of give all employers some basic tips for the biggest problems I see is failing to document problems. If you have an employee who is always late, who is always making mistakes, who is always, they're rude to your customers, and you just kind of, oh God, I can't stand it when she does that. But, I don't feel like disciplining her. I don't want to be a bad mood. I don't want to be a bad boss. And then it comes time when you're fed up and you want to fire her, and you have never documented that there was a problem. She is going to come back and say, you're not firing me because I was late. You're firing me because I'm 47 and you think I'm too old for this job, and you want to hire somebody younger and cheaper. And you're going to say, no, you were late to work every day. Well, where's my write-up? Where's my discipline? If it was a big deal, you should have documented it and you should have disciplined me for it. So it's that is the biggest problem. And it's so hard to discipline people when you don't have that type of spirit. A lot of people just do not like confrontation. But as a business owner, it is imperative, because you're going to find yourself in a situation that you can't get out of because you didn't document it from the very beginning. The other thing is to create a policy and procedure manual so that your expectations are clear. Your workplace rules are clear to your employees, and they know exactly what's expected, and they can't say, I didn't know. They can't say, you never told me that. You put it on them to read the manual and be responsible for everything in it. Now, you want to make the manual general enough so you're not tied to anything that you can't get out of, but you also want to make it specific enough so that it's clear what your business is, how you want it to be run, and what's not going to be tolerated. I have a lot of examples of policies and procedure manuals that I'm happy to share samples of if you like, because you definitely need that. Also want to consider non-compete and non-solicitation agreements with your employees. You don't want them to come to your business, learn all your information, learn all your trades, and then take it and go give it to the next employer. So you want to see if you can have them sign non-compete agreements, non-solicitation agreements, so they're not stealing your other employees and going to start their own business with all the tools that you gave them and they learn from your business. And the other thing is background checks. In addition to employment laws, you can also be sued for common law torts like negligent hiring, negligent retention, negligent supervision. If you have an employee who has a violent criminal background and you didn't find out about it, and then they come in your business and they attack one of your other employees or attack one of your customers, they can sue you for not knowing that. You should have done a background check. You should have figured it out. And those are real and they're costly. Tricky thing is, the EEOC does not allow you to use background checks to make hiring decisions unless you do an analysis of the background itself with the job. So say you do a background check and every time someone has a felony, you say, I'm not hiring you. But you haven't done an analysis about what the felony was, how long ago it was, and if the felony has any impact on your business. So if you're running a business and you're running a leaf blowing business and you have someone that was convicted of check hiding, how is check hiding going to impact your leaf blowing business? So you have to do an analysis of what the crime was and if it would directly impact operation of your business. Now, if you have someone that has a background for, theft, and you run a financial institution or financial services, tax service, you don't want somebody who is capable of theft around sensitive financial information. So that would be justifiable that you wouldn't hire that person. So you have to do a background check, but you can't use the background check to not hire criminals, period. You just have to do analysis for every person that you come across.
So Camila, we have a question from Alton, and we've got 3 minutes left in your segment. So Alton, go ahead and ask your question.
Good morning. Camila, I wanted to go back to the non-compete clauses because in my industry, the financial services industry, we're always signing non-compete clauses. There are literally lawyers out there that are searching out these opportunities and saying that they can get you out of the non-compete clauses almost no matter what. So the interesting thing, when do you normally see those types of clauses used, and are they really enforcing those at this particular point?
So I do understand why you say that, because there is a big push to not be so restrictive and allow the covenants to stand if they're unreasonable. But the courts usually say that 2 years, 1 to 2 years, not allowing an employee to compete in a reasonable radius. Like if you have a small business in Orlando, you can't say you can't compete with me in the whole state of Florida. Usually they'll narrow it to Orlando, but you can go to Tampa, you go to Miami. If you have a statewide business that's in a bunch of cities, then maybe it's fair to restrict you from competing in the state of Florida. It just depends on the type of business. But a lot of restricted covenants they're too broad, and they don't allow people to work. So the courts do not like restricted covenants that don't allow people to make a living. So they will narrow it down as much as possible to make it fair. But it really depends on the individual business and the employee and the relationship. So there's not a particular industry that does it more. I see it everywhere and I encourage it. I think it's a good idea. It just has to be reasonable.
Thank you so much. Camila, we did have several individuals that would like a sample that you have of policies and procedures when hiring employees. So if you could get that to either myself or Rosalind, and then we will send that out as part of the recording and follow-up email.
Okay.
I know that Nadine had a question that says, is there a difference between an hourly position person and a manager salaried in regards to overtime? I've heard that if you are in management position, amount of time you work is not limited to a certain amount of hours, which I know
That's
that
right.
you answered that earlier.
That's exactly right. If you're a
Yeah.
manager and if you manage more than 2 people and you have the ability to hire and fire people, you can be exempt from overtime. So you don't have to worry about how many hours that person is working. That's absolutely right.
And we're ending right on time with your segment because I know you have to leave. So Camila, thank you. You are a wealth of information. We have her contact information up here for you. And we really appreciate you. Rosalind, I think I answered, or before she leaves, I think we have all the questions that were asked of her.
I think
All
so.
right.
Thank
Okay.
you so much.
Thanks, Camila. We appreciate you. I am the next speaker that is up. While we're getting the slides up, if you don't mind, just putting your contact information in the chat. You never know who may need your services. If you could just share with us your name, the name of your business, and what you offer, and your contact information. If you could put that in the chat so that we are able to just provide that and others are able to see it. So what I'm going to be talking about this morning, and Camila kind of talked a little bit about it. First, the announcement.
Yeah.
DPI has an online course that we have available. There's so much that has been talked about regarding employees, independent contractors, interacting with your employees. And so we have a course, Belonging Matters, which is available online. We are offering to you all 50% off. This is only the second time that we've offered 50% off. So if you want to learn more about the online course that we have available for you. It's 5 modules. We ask that you commit like 1 hour per week. And it's just a wealth of information, especially for business owners, anybody in leadership. You can scan the QR code and it will take you right there and provide you additional information, some videos on there that will introduce and share with you what it is. You see the coupon code there, so take a picture, make note of it so that you can have that for your records.
Yes,
Oh,
and I know that Renee, before you start, because I'm going to do a little introduction
oh,
for
you
you.
are okay.
I know that she talked about if you have employees, and I think all of us are understanding how you don't take it lightly when you are entering into agreements and hiring. It is something to take very seriously as a business owner. It is why we are providing this free information to you and having this community. Really, we are a community. That's why we want you to share your contact information. But I want to piggyback on something she said. Camila talked about the more turnover causes you to have higher employment taxes. And I think it's so important that you develop your skills as a leader. And that's what this online course will help you know how to. When she talked about documenting, that is in there. Also, just being able to have a very inclusive culture, because there are so many ways that it can be a risk if you don't know what you are doing in regards to developing a team, but also managing that team. So I encourage you, this 50% off is for a limited time, but we always want to be very gracious with our community of business owners. So it is my pleasure to introduce to you my identical twin sister. I know I have a lot of clients on here, and they might not know that I have an identical twin sister. She is co-founder of DPI LLC. She is the wife of Alton, who is on this call, but she is also an insurance agent, an independent insurance agent, Renee Scott Insurance. And she is committed to taking the pain out of shopping for insurance. And one thing that she really wanted to talk about was workman's comp. And I think you heard Camila talk about how that can get very expensive if you do not have it. And so we wanted to make sure that we covered many bases as we can. So Renee, owner of Renee Scott Insurance, she is a trailblazer, has been in insurance for almost 30 years at this point. So Renee, take it away.
All right. Thank you, Rosin. I appreciate that. So when she talked about workers' compensation, I'm like, yes, because in the state of Florida, and I know that we have Alabama also on the someone from Alabama, a business owner from Alabama that's on here. But in the state of Florida, did you know that it is a requirement that if you have employees, and I am talking about W-2 employees, you are required to provide workers' compensation insurance. Now, as she shared, depending on your industry, do you need to have it from employee 1? Or do you need to have it from employee 4? It varies. So if you're in the construction industry, absolutely 1 or more employees. And I want to make sure you understand that includes you as the business owner. With regard to non-construction, 4 or more W-2 employees, you have to have workers' compensation. Now, if you are a non-construction, like me, as an insurance agency owner. If you're a sole proprietor or you are a partner in a partnership, it is not, you don't have to be included. Your employees, you don't have to have, at the point of 4 employees, you don't have to have the workers' compensation. If you're in the agricultural industry, if you have 6 regular employees and or 12 seasonal employees, workers' compensation is required. Now, that's the requirement for the state. I would venture to say, if you have 1 employee, you need workers' compensation because you stand at risk to be sued if an employee is injured while on the job or even traveling for your job. We just had our college roommate. She was on travel with her job. She fell in the hotel and she now has a torn meniscus or something of that nature. That is going to fall under workers' comp. Now, if you go into the premise, well, oh, I don't have to have workers' comp, I only have, I have less than 4 employees, what's going to happen when that employee submits the bills to you for their medical injuries? So that's what I want you to think about. Even though the state has their requirements, you really want to think about having workers' compensation from the very first employee. All right. Now, the rates for workers' compensation is set by the state. So no matter who you get your workers' compensation from, those are going to be set by the state. The highest amount of workers' compensation is painters. I don't believe we have any painters or painting companies. That's the highest amount. If you have a desk job, your workers' compensation rates are extremely low. And when I say extremely low, like maybe $200 for the year. But the more risk there is for an employee to get injured, of course, you're going to have higher rates. The second insurance that is needed, so not just workers' compensation, is your general liability. And I really want to discuss this from a standpoint of if you have 1099 contractors. So let's just say you have a virtual assistant or you have someone that's renting a booth from you if you are an esthetician or something of that nature. General liability is really the most common business insurance that all business owners have. It is there to protect you in the event of a lawsuit. If you are sued, or if you, let's just say, own a business, you are a janitorial service and you are cleaning and one of your employees or your 1099 contractors damages a part of the furniture that they are cleaning. If you have W-2 employees, they are covered under your general liability policy. If you have 1099 contractors, they may or may not have coverage under your general liability policy. And I see this all the time. It varies based on the type of insurance you have and the insurance carrier specifically. So if you have 1099 contractors, I always suggest with your 1099 contractors, they're independent. They really need to have their own general liability insurance because they are most likely not covered under your general liability insurance. So what that means for that janitor, if they're hiring subcontractors, right, to go in and clean office buildings or whatever the case may be, they cause damage, you get sued, that's not necessarily going to be covered under your general liability policy because they are not W-2 employees, they are 1099 contractors, which ultimately means they're independent. They need to have their own general liability insurance. So I wanted to briefly just share those 2 different types of insurance. I only wanted to take like 5 minutes, but of course, if you have any questions, feel free to ask whatever questions you may have. But that is all that I have for you. And hopefully Lisa has had an opportunity to join in. Okay.
Yeah.
And Rosin,
So-
I haven't been looking at the chat, so I don't know if there were any questions. Oh, Peter,
Yeah.
you have a question.
Yes, excuse me. So we sub out a lot of the work that we do when we're doing installations of the artificial turf.
Yes.
So when I sign a contract with a builder, I'm providing them my workers' comp and my general liability, but yet I'm hiring another company that's the labor company side of it, and they're the ones that are coming out and doing the install.
Mhm.
Should I be, I'm guessing I need to get a certificate of insurance from them for workers' comp and general liability, but is my company listed as the additional insured, or do I need to connect the dots all the way back to the builder
That is
that gave
such
me the
a
contract?
Peter, that is such a great question because we get that question quite a bit. When you are hiring someone like you are, you're basically just overseeing it and you're hiring your subcontractors. They need to have their own general liability policy, and you need to be listed on their general liability policy as an additional interest or a certificate holder. I want to give your Ida as an example. She is doing it the right way. She has independent contractors. She's an esthetician. She has individuals that are working for her. They are independent contractors. She has to present to her their insurance. They have to have the same coverages that she has from a standpoint of general liability, and they have her listed as an additional interest. That is the absolute best way to make sure that you are covering all bases when hiring independent contractors.
Got it. Thank you.
You're welcome. Erica.
So I wanted to see if this applies. Again, my business is TPE coaching, and that's the one that I've been kind of running, and I have a virtual assistant for that business. But I was because I'm a speaker, a professional speaker, I had to get something called occurrence professional liability insurance, and in order for me to speak at different venues. Does that, because it says right there, the specialty is life coaching, and it says, I don't know, general procedures. Does that cover my virtual assistant, or that's completely separate? Is
So
that me service? You know what I mean?
yes, is your virtual assistant a W-2 or a 1099?
Well, based on Miss Anthony, I've just learned that she's a 1099. And
Okay.
so yeah, I just got her, and so that's why I'm on this call, because I wanted to learn how to apply her. So it looks like she's fits the role of a 1099,
Yes.
and how I'm going to proceed it.
Yes. So I would have a conversation with your agent, but most likely that 1099, your virtual assistant, is not going to be covered underneath your general liability policy, that policy that is needed for you to contract with different locations to speak. Now, your virtual assistant may not be interacting with them and may not really have any interactions, and so there may not be a need to have coverage. But if you're hiring a 1099 employee or concept independent contractor, they really need to have their own insurance.
Oh, okay. So okay, gotcha. I understand. Thank you.
Does that make sense?
It does, because I think that what you're saying is also she doesn't necessarily deal with, anything like client related. It's more like in-house work for me.
Right.
So, gotcha. Thank you.
You're welcome.
So thank you so much, Renee. I know that we have shared a lot of information, and some of you might be thinking like, oh my gosh, I never want to hire. I'm just going to stay in this. I want you to get rid of that limiting belief. This is why information is power. I want you to know having employees, having subcontractors, that's a part of your competitive advantage. So you want to be able to leverage when you hire, you want to be able to find the skills and talent that you need to take your business further, faster. So don't be afraid. That's why information truly is power, and DPI is dedicated to giving you that real-time information in your business. So right now, we've covered so much. We've covered taxes, we've covered legal, we've covered insurance. We want to really talk about the human side of leadership. How do you hire someone? What is your first step? And so I would like to introduce you to our final speaker this morning. Lisa Perez is a USA Today best-selling author and the founder and president of HR consulting company HBL Resources Incorporated, HR Support and Training Membership Platform, The Complete Manager Makeover, and National Management Training Week. She is on a mission of transforming the human in human resources. As a member of SHRM, she holds 2 nationally recognized HR certifications, and her firm is designated as an approved provider of recertification credit programs from both SHRM and HRCI. As a certified bridge builder, she facilitates generational diversity workshops and is a DISC certified human behavior specialist. She's recognized throughout her 30-year HR career, including 2 2020 American Business Awards Silver Stevie Awards for Entrepreneur of the Year and Human Resources Professional of the Year. I can tell you, I know Lisa personally. She's a part of my chamber. She is on the board. She volunteers with the Jim Moran Institute. She's a part of SCORE Broward County's Kapow program, and a part of her local church. She is just phenomenal. I am so excited that she is here. So Lisa, I am going to stop sharing. I know that I had sent out her slides, so there are notes that you can take yesterday. If you didn't receive it, do not worry. But let me see. Feel free to share screen.
Thank you so much. It's so great to, I'm going to ask for grace.
Yes.
As I am getting over quite a cold.
Okay.
And I didn't cough the whole time you were talking, but of course that happens. Well, thank you again. You know, the human element is my jam, right? Transforming the human and human resources. But today's conversation is going to be a little bit of the process and a little bit of that human aspect, right? Because we really want to equip you to build on what you've already covered. I know we've covered a lot of the legalities. I know that you guys have talked about some of the laws that you have to ensure that you're in compliance with. You know, that's a big part of my wheelhouse as well, because everything you do with your employees, whether they're a W-2 or a 1099, will trip wires, as I typically say. So I know I have really short on time today. This, full disclosure, this is typically a 1 hour at least conversation. We're going to jam pack it into 10 minutes. So let's get ready to rock, okay? We're going to first know some steps to take before hiring an employee, and you've already heard a few of them. The consideration of workers' compensation, making sure you've got service contracts for your 1099s, things of that nature. We're going to touch on some of the laws. We're going to get you prepared for an interview. We're going to make sure that you are asking appropriate interview questions to gauge that you're really hiring the best candidate and not just someone who you really got along well with during that interview, right? And then we're going to understand some basic personnel record keeping requirements, and then of course maximizing that onboarding so that you can make sure you keep that person. But let's first look at some of the legalities. We're going to talk from a federal perspective, and I'll touch on some Florida state as well. Do we have anybody outside of Florida in the room today?
We do have someone from Alabama.
Well, HBL Resources does touch all states. We are based right here in Miramar, Florida, in South Florida, but we do have clients throughout the United States. So we'll keep this from a federal perspective, and I'll share my contact information so that each of you can schedule a call with me, a complimentary 30-minute consultation, because you are in the DPI family, okay? So you want to make sure that you're registering first from a federal perspective for a federal ID number. You probably already have that. Where you're going to need that documentation as you begin to consider maybe outside payroll systems. You might be utilizing QuickBooks, but that FEIN number, that social security number for your business, is going to be required as you begin to navigate payroll processes and things of that nature. You'll want to consider what's the best payroll system so that you can make sure that you're withholding taxes from your W-2 employees. You're not to do that, obviously, with 1099s. They're responsible for that, and your contract with them should indicate that. The IRS Form W-4 is the document used for any employee, your new hire. At a minimum, that is required in addition to the Form I-9. This is a federal form that is put out by the United States Citizenship and Immigration Service. This document ensures that you are taking identification so that you know your hire is who they are, the identity, and that they have authorization to work in the United States. If you do not have a Form I-9 for each employee, W-2 employee in your organization, you're not in compliance. And these are pretty hefty fees that can be, you can be fined for. So make sure you've got those things at the minimum. You also are required to post federal notices and state notices, and in some cases, local ordinances as well. The best place that I would recommend for you to get that is a website called allinoneposters.com. You can say what state you're in, and what locality you're in, and they will ship you. It's about $40 or so for all of those posters. Now, there are some ways that you can get those free of charge with the Department of Labor. That's the DOL.gov, departmentoflabor.gov. And you can just Google, departmentoflabor.gov and poster requirements. And you can print those out and put them, post them in your organization on your, cafeteria wall, the beautiful black, white, and red posters, right, that we all love. And so you make sure that you're in compliance with the poster requirements. Maybe you're a completely virtual organization. That's okay. You still are required to have those posters. I would recommend that maybe you use your intranet system wherever you have internal communications. Maybe there's a SharePoint where everybody sees your handbook or your posters and all of that. You still are required to have those even in a virtual or an all remote workplace. Keep in mind that there are also OSHA workplace safety laws that you must comply with. Now, from a brick and mortar perspective, what's your fire evacuation plan? What are your safety protocols? What happens if there's a fire? Where do you all go, right? So that we can do a head count that I got all of my, employees that were in the building, out of the building, right? And like I said, this is an hour-long conversation. So we go into great detail on all of that. And I highly recommend you get, on my newsletter so that you can see and hear when these updates are happening and when I'm offering complimentary webinars, so you can check out the full hour. So then you want to consider payroll taxes. I don't know if this was covered, but a reputable payroll company will ensure that you are properly filing your FICA, FUTA, SUTA. Those are federal income taxes, federal unemployment taxes, and state unemployment taxes. Those are required, and you want to consider when thinking about this from a monetary perspective, whatever that employee is going to make, add 7.65%. And that is what you can anticipate in taxes. Okay, that's Florida state specifically, but that's for all of the federal requirements. So that gives you an idea on the monetary lift that you'll have to do in addition to that wage. Okay, now let's talk about your state labor department. We already talked about workers' compensation, and most payroll companies might integrate the cost of that in a pay-as-you-go process. So write that down. Do you offer pay-as-you-go so you can pay your premiums with each payroll? So that's something to consider. But you also have to apply for a SUI number, the state unemployment insurance number, right? So that you have an unemployment account. It's just like a holding account where you're paying your taxes into that. And if you should have a unemployment claim, the claims are paid out of that bucket, if you will, okay, for layman's terms. Now, you also want to consider workers' compensation insurance. And again, Renee is your expert for that. Know your state minimum wage. The state minimum wage in Florida has been inching up. It's intended to get to $15 an hour over the next several years. And it just went up September 30th to, I believe this year was the $12 an hour. So keep that in mind, that if you're in the state of Florida, make sure that you're at least paying that minimum wage, and that your state minimum wage, if it is lower, than the federal minimum wage. It really shouldn't be, but then you always have to pay the higher of the two. If your state minimum wage is higher than the federal, most of them are, then you'll want to make sure you're always paying the higher amount of minimum wage in your state. Now, there's also something called state new hire reporting. When vetting your payroll companies, make sure that you ask, do you offer state new hire reporting? This is because when you hire an employee, it is incumbent on that state reporting agency to find out if there are any garnishment orders, child support orders, alimony orders, right? And when you file that new hire as you're reporting your new hire, then those government agencies know where that individual is, so those wages can be garnished as according to the law. So the state new hire reporting is a requirement. If you don't have that in your payroll system, then if you're using QuickBooks, right, and QuickBooks doesn't offer that, then you must make sure that you know where to report your state's new hires. And then, of course, you have the state required notices and posters that I mentioned before. And again, allinoneposters.com. I get no commission. They're just the most affordable and fastest service is where you can get all of your federally and state and local required posters. Let's see. And I'm going to have some time for questions in the end, so no worries. It is really critical that you have an employee handbook, even if you have one employee. There are many notices that we just talked about, federal, state, and local. You'll want to make sure that the handbook, although there's really no requirement, the requirements come with all the notices that you're required to give. Now, would you rather give a notice at 20, 50, 60 different notices because you have federal, state, Affordable Care Act notices? There's so many notices. Would you rather give them all, haphazard, or put them all nice in an employee handbook, present for one signature, right? So that is something that you want to have. It outlines your policies, procedures, your record keeping processes, your payroll processes, your work week, when they get paid, what benefits you offer, right? All of those things are important. So I do employee handbooks for small businesses so that it reduces the amount of questions your employees have. Why? You've put all those questions nice and neat in an employee handbook. Now, you also want to remember that personnel files must be kept. Record keeping is also a federal standard in terms of what needs to be in that employee file. You'll want to make sure that you have documentation of what the employee agreed to make, what they didn't agree, what the wages were, what the benefits were. That's where the handbook acknowledgement comes into play. Those all need to be in the employee file. I do not recommend my individual clients use put the I-9 form in the employee file, because if you were ever subject to an audit of that I-9, then you would have to provide the whole file. You don't have the ability to take it out at that time. So keep those in binders or a separate folder, alphabetical order, so that if ever audited, all you have to do, hand over the I-9 folder without them seeing the other parts of the file. Outline your benefits. Consider what the math is, right? What is the financial impact to offer vacation or sick or a PTO program, your simple IRA, 401ks, health and welfare, cafeteria plans, ancillary, AFLAC, right? All of those things, and some of the perks that you might be able to offer as well. So when we look at the illegalities, I know we touched on independent contractor versus employee, so I'm going to skip over that, but we do offer a guideline on how do you treat an independent contractor versus how do you treat that employee. And I'm going to encourage you to get our full resource guide on hiring your first employee. I think there's like 20 something pages in this thing, and it will give you all of the links and all of the resources to where to find some of the websites that I mentioned, some of the compliance, if you want the do-it-yourself type of way to do that. So I encourage you to get that QR code should already be in your handout. So definitely, get that as a resource. Couple of things about non-discrimination and interview guidelines. Please make sure that you have a formal employment application. And by application, that could be a digital application in your Indeed account or your ZipRecruiter account, but that you're asking the right questions and that you're asking the questions correctly. I don't know if they covered this in the legal section, but there is a way in the state of Florida still to ask about the background check and the conviction. Have you ever been convicted of a felony and all that? There are various changes in the nation that not all states are permitted to put that in the application process. So please make sure that you're asking some consistent questions, that you've got your disclaimers in your application. And again, during our 30-minute consultation, your complimentary consultation, if you take advantage of that, if you send me your application, if you have one, I'm happy to look at that and say, this needs to change, add this, take this out, that kind of thing, complimentary as a DPI community member. Keep in mind that you should never write on an application. And so you'll want to make sure that you have some kind of form to collect your notes. If you're interviewing 5, 10, 15 people, they all start getting, all confused at the end of the day. So you'll want that form to do a couple of things. One, ask some consistent questions of everyone, right? Uniform guidelines is a federal act that says, let's be uniform. Let's make sure that we're treating every candidate, every applicant uniformly, okay? And an application process, an applicant screening form with specific questions that you ask of everyone is very important. Now, you'll always ask specific questions based on their experience, but definitely want to make sure that you're not putting any notes on an application, but do have somewhere where you keep that in the event you ever had to prove why you didn't hire someone and that it was not an illegal reason not to hire them, as many of the laws you already covered can be tripped. We do use a PRIDES model of interviewing. How much time do I have in my 3 minutes? You
have 2 minutes remaining.
Okay, so your interview process needs to be what we call the PRIDES model. You've got to prepare. You need to make sure that you know the job yourself, have reviewed the resume. You want to build rapport during that interview. How are you? Nice scarf. Did you find us okay, right? Information gathering is the biggest part. What questions are you going to ask? Ask a mix of open and closed-ended questions. We use the behavior-based interviewing model so that I know, based on what you've done, what you're potentially going to do. You'll want to also describe the position, the company, your mission, your vision, your values. What is the organization? Where am I going to be working? Is it a cubicle? Is it an office? Is it virtual? What kind of connections am I going to have that you have or that you're going to provide to me, right? All of those kinds of things. And then, of course, expect questions. If they don't have questions about your organization, did they really vet that process a little bit in terms of wanting to specifically and really work for you? And then summarize next steps. Let your candidates know, what's the next step in the process. Is it going to be a week-long decision, a 2-week-long decision? But that PRIDES model of interviewing will be a good standard for you to follow. And then, of course, I invite you to connect with me. I hope you learned a few new concepts. I know I talked really fast, but hopefully that gave you at least a little bit of information and an overview of those federal requirements for hiring your first employee. Please do get that resource guide. It will serve you well. And I thank both of you, Renee and Rosalind, for giving me an opportunity to speak to your community. Connect with me on LinkedIn and let's continue the conversation. I think I'll get a list of the individuals here, or maybe I'll take a screenshot. So if I see you hook up on the LinkedIn and schedule a call with me, it'd be my pleasure to serve you complimentary for 30 minutes. Get those questions ready, my friends. I'll look forward to serving you.
Thank you so much, Lisa. I know we have provided quite a bit of information. It may seem overwhelming. We have great resources for you and the individuals that spoke. Please don't delay in having a conversation with them regarding whatever questions you may have, just to make sure that you're on the right track and that you are doing what's right by your employees, your business, as well as your 1099 contractors. I do want to ask, do we have any additional questions? We have about 6 minutes remaining. Are there any questions at all for Lisa?
I have a question.
Go ahead.
So with the remote employee that might be based in a different state, are those state laws gonna apply and trigger, or you're doing Florida as well as wherever else you're going?
Yeah, you're governed by where that employee sits, right? So if they're sitting in a different state, great question, then they are going to be governed by those states. You'll want to make sure that you're paying the taxes that are required of that state. They may have specific ordinances where they are, so you'll want to know those as well. And I'm happy to, guide you with those when you schedule a call with me. So what state is it, if I might ask?
Texas.
Okay, at least there's not a state tax there.
Yeah.
So
Yeah.
we've got some similarities. Yeah.
That was a great question, Jerry. I
Very-
didn't even think about
Mhm.
that
Yeah.
from a standpoint of hiring someone out of state.
And-
Alton, I know you have a question.
Yes, Lisa, thank you very much. In some interviewing models, they will use I guess, a behavioral analysis test as part of the interviewing process. Do you suggest that? Or if you do, are there any particular tests that you find more
Thank you.
conducive and effective than others?
Yes, thank you for that. So, you heard in my bio, I'm a DISC certified human behavior specialist, and I've looked at them all, and I believe that DISC really does hit the highlight there. They do offer a hiring insights assessment, and so what we do is we take a profile of the job. Or do you need an outgoing person, an introverted person? Because the last thing you want to do is put someone who loves to talk to people all day in front of a computer, right? And just have them sit in front of a computer all day. So the DISC assessment, through its hiring insights, matches a person with the position, but it's one part of the entire interviewing model, right? It can exclude someone and it can include them, but you still want to have that conversation as well. It's one piece of the big picture of that candidate. But that's a great question. Thank you for that. I'm a huge fan of the DISC model.
Yeah, I've even had it used as a subcontractor to make sure that I was filling the gap that who
Entrepreneur.
Yeah, that I would be partnering with, that strategically I was put on the right projects.
Yeah.
So yeah, I think if it's W-2 or even 1099, you can include that.
Absolutely.
Yeah.
Great question.
Anyone else? I
Can
mean,
I follow up to Alton's question?
Yeah.
So
Go ahead.
looking back at the DISC profile, so I hear a lot where you go, let's evaluate the employee with the DISC profile and the job description. But do you compare the supervisor owner personality to that employee's personality to see if that meshes?
Yeah, thank you. So it depends, right? Because sometimes the supervisor is already selected, right? That employee's adding to an already selected leadership team. So what my recommendation always is that let's go in and do that DISC training. Let's kind of highlight who we all are and how different we are, but how we're the same and where we can complement each other, right? That's that human element that I was talking about. So that if I know I'm an aggressive supervisor, but my team member is really a little bit more reserved and shy, I need to approach that person in that way. And the DISC can help you with those relationship and leadership dynamics. Thank you. Yeah, I love me some DISC because it connects people, right? It connects them.
Yes.
Good to see you, Erica. Erica had to leave.
Yes.
Yes.
To everyone, thank you. Let me just kind of share screen. So some follow-up here. So thank you so much. Don't forget, as we had said earlier, thank you so much, Lisa. I appreciate you being on, and I know you were running from one meeting to the next, but I know that I have learned so much as a business consultant, and can't wait to kind of really pass this along and connect people with the right expert to help them. Don't forget, we have our leadership development training, 5 modules, about a 90 minutes a week commitment. But this is definitely going to help you on your journey. And we just want to say a special thank you for being here, giving up part of your morning. We want you to have a wonderful weekend. And this is the end of our presentation. Thank you so much.